Again. There we go.
Okay. Welcome, everyone. This is the May 9th Kansas City League of Women Voters Observer Corps committee meeting, and we are so pleased to have the opportunity to hear about the Missouri Sunshine Law from Jay Turner, who's in the Kansas City office of the Attorney General. Jay grew up in San Diego as a child of two law enforcement officers. He spent most of his career working for the state of California as a state parole agent with Department of Corrections and Rehabilitation, and later in security fraud enforcement with the Department of Financial Protection and Innovation. Jay moved to Missouri in 2015 and took a position with the Attorney General's office, working on a variety of civil and criminal cases. In 2017, he was promoted to public safety manager and signed Sunshine Law's duties as the AGO's point of contact for criminal investigation and prosecution records. In February of 23, Jay was promoted to Director of Sunshine Law Compliance. In this role, in addition to conducting Sunshine Law presentations across the state, he and his team investigate alleged violations of the Sunshine Law by Missouri public governmental bodies. We thank you so much, Jay, for being here, and I'm turning it over to you.
Excellent. So I want to thank the League of Women Voters for having us here today to do this presentation. I'm joined here by Jason Lewis, who is the General Counsel for the Attorney General's Office. Jason will just be observing and answer any questions that I may or may not be able to answer. So that's why Jason is here observing. So this presentation today is the Missouri Sunshine Law. And this presentation is not to be considered formal legal advice either by myself or by the Attorney General's Office. Full disclosure, I am not an attorney. I cannot provide legal advice. The Missouri Revised Statutes, Chapter 27, talks about who the Attorney General is authorized to provide legal advice to. And by law, that is state departments, state agencies such as the Department of Corrections, the Department of Mental Health, the Department of Health and Senior Services, things along those lines. Our office generally cannot provide legal advice to local public governmental bodies, counties, cities. So a lot of times when people contact our office and ask, is this meeting open or closed? Is this record open or closed? We usually refer those questions back to the legal counsel for that particular public governmental body. We can only give guidance and best practices. And in certain situations, we might be able to tell how our office might view a particular complaint, but we can't actually give legal advice unless it is a state agency. So just wanted to make sure that everybody was aware of that before we moved forward. This is a quote that I came across that I think sums up what the Sunshine Law stands for. Democracies die behind closed doors. When government begins closing doors, it selectively controls information rightfully belonging to the people. Selective information is misinformation. I'm sure you guys have all heard of FOIA, or the Freedom of Information Act, when it comes to public records requests. FOIA is actually a federal law that applies to federal government agencies. It does not apply to the state of Missouri. When someone in Missouri makes a FOIA request or a Freedom of Information Act request, what they're in fact making is a Missouri Sunshine Law request. So if a public body receives a records request and it references FOIA or it references the Freedom of Information Act, a body should interpret that as a public records request if it can do so. We have had situations where a body has said, well, the person made their records request pursuant to FOIA, and FOIA doesn't apply to us, so we didn't respond. That's not a best practice. If a body can interpret a records request as being so, they don't necessarily have to specifically reference the Missouri Sunshine Law, or if they reference FOIA. So we advise public governmental bodies to just bear that in mind. And also during this presentation, I'll refer to public governmental bodies as a PGB. And that's because saying public governmental body multiple times in a presentation is, it's a very long couple of words. So just trying to shorten it, I'll refer to a PGB. So if you hear me refer to a PGB, that is what I'm referring to. So what is the Sunshine Law? So it is the public policy of the state of Missouri that all meetings, records, votes, actions, and deliberations of PGBs are open to the public unless otherwise provided by law. Section 610.010 to 610.200, which is the Sunshine Law, shall be liberally construed and its exceptions strictly construed to promote this public policy. And basically what this means is all meetings, records, votes, actions, and deliberations of PGBs are presumed to be opened. If a public body is going to close those particular things, they need a legal reason to do so. And we will talk about some of those legal reasons later on in this presentation. The takeaway from that is public business is the public's business. And you'll notice down in the lower right-hand corner, we have a legal citation and a page number. We have a Sunshine Law booklet on our website. So if you were to go to that booklet on our website and look up that particular statute, that is what we're talking about here on the screen, and the page number is where you can find that. We also have physical booklets. I know a lot of citizens and public bodies want the physical booklets to be able to hand out to people. So if the League of Women Voters is interested in getting those booklets to be able to distribute, we can certainly provide those to you. Personally, I prefer the online version because when I'm investigating a complaint or trying to find something specific, I can always do Control F and I can find certain keywords in that. So a lot of people prefer one over the other. I prefer the online version, but if you do want those physical booklets, we can certainly provide those to you. So whom does the Sunshine Law apply to? So it applies to Missouri public governmental bodies, and that would include municipalities such as cities and villages. It applies to counties. It applies to police departments, special districts, and committees. There was a study done by governing.com a few years back that looked at public governmental bodies across the United States in relation to population. And Missouri has almost as many public governmental bodies as the state of New York, and they have 3 times our population. And part of the reason for that is Missouri has a lot of special districts. We have ambulance districts, we have fire districts, we have library districts, we have taxing districts. There are a lot of special districts here in Missouri. I also mentioned committees. So say if a city or a county appoints a budget committee to study the budget. So then you have the parent governmental body and you have a budget subcommittee. Because that budget committee was created by and responsible to that parent governmental body, the Sunshine Law would apply to that budget committee as well, and all other committees that are created by the particular PGB. So how does the state of Missouri define what a public governmental body is? So under 610.010 subsection 4, it's defined as any legislative, administrative, or governmental entity that's created by the Constitution or statutes of this state or by order or ordinance of any political subdivision or district. And those political subdivisions and districts are the ones that we referred to on that previous slide. So this is where it talks about if a committee or a governmental body creates another body or a committee or an advisory committee, the Sunshine Law would apply to those as well. And what that boils down to, it's the power to govern, the power to formulate policies and procedures, to promulgate statutes and ordinances. It's the exercise of quasi-judicial power. So what about committees of a public governmental body? So I did mention general committees that are created, a budget committee, but say that budget committee creates a subcommittee. So now you have a parent governmental body, such as a city council, then you have a budget committee, and say you have a salary subcommittee. So you now have 3 levels of those committees. Because that subcommittee was created by that parent governmental body, it has the same reporting requirements as that parent governmental body does. That would also apply to a situation where a public governmental body created an advisory committee. Say, for example, that it created a committee of private citizens to study a particular issue. Say a body was going to study a proposal for to build a new health department or a new police department. Again, because that advisory committee was created by and responsible to that parent governmental body, the same reporting requirements would apply to that advisory committee as it would to any other committee that was created by that PGB. So who is not covered by the Sunshine Law? So our office gets about 40 to 50 complaints a month from a variety of different areas. So some common examples where the Sunshine Law would not apply would be, for example, private entities. So that would be Subway, Target, Walmart. Those are private businesses. They're not PGB, so they would not be subject to the Sunshine Law. Homeowners associations and property owner associations. I think that people think that because those associations have boards and they take minutes and they post notice of their minutes, that they must be a PGB, and that is not the case. The homeowners associations and property owner associations are private organizations. They are not subject to the Sunshine Law. Non-Missouri public governmental bodies. So this would be federal agencies or agencies based out of state. As we previously talked about, FOIA or the Freedom of Information Act would apply to federal agencies, whereas out-of-state agencies would apply to their particular records acts within those states. In California, they have the California Public Records Act. I think in Florida, they actually refer to it as the Sunshine Law, as Missouri does. So each state usually has their own Public Records Act that applies to their public records. But obviously, the Missouri Sunshine Law would not apply to those out-of-state entities or those federal entities. Judicial entities when not operating in an administrative capacity. So the courts have administrative responsibilities just like every other public governmental body does. So if, say, the courts created a budget committee or something along those lines to study an administrative issue, that would be a situation that would likely mean the Sunshine Law would apply. But if the request or the complaint is regards to court records or items off of CaseNet, that's generally the courts operating in a judicial capacity. And generally, the Sunshine Law does not apply in those situations. The Missouri courts actually have their own rule, Missouri Supreme Court Rule 2, which would apply to court records. Nonprofit corporations. So a vast majority of nonprofit corporations are not subject to the Sunshine Law. Those are, again, private organizations. There is a very narrow area of the Sunshine Law where a body could be considered what's referred to as a quasi-public governmental body, and quasi meaning part. So there are specific requirements that that outline what could be considered a quasi-public governmental body under the Sunshine Law. One of those benchmarks is that the entity has to be a nonprofit organized under specific chapters of Missouri law. That's usually, I believe it's 353 and 355 of the revised statutes of Missouri. If it meets that benchmark, there are other benchmarks that it has to meet as well. It's a very nuanced area of the Sunshine Law. It's still evolving here in Missouri. In fact, over the last couple of years, there have been some court decisions that have kind of modified and altered what would be considered a PGB. And if you're interested in that particular, those particular entities, the court case is Malin, M-A-L-I-N, and I believe it was Malin versus Task Forces, I believe is what it was called. Most individual employees or board members. So the Sunshine Law only applies to the records that a public governmental body retains. It does not apply to records that you hold as an individual or applies to you as a board member, but only to records that are maintained or retained by a public governmental body. Section 610.028 of the Sunshine Law states that every public governmental body must have a policy open to the public for inspection regarding the release of information on any meeting, record, or vote. So this is the section of the law that requires every public governmental body in Missouri to have a Sunshine Law policy. They also have to have a custodian of records named by law. If a body doesn't already have a Sunshine Law policy, we actually have a sample policy on our website. I believe it's in the form of a resolution, so the body can download that. They can modify it to their particular public governmental body. And in the Sunshine Law policy for a PGB, we recommend that you include provisions about how your meetings are held, procedures for searching and producing certain records, how your fees are calculated, and how your body goes about responding to a public records request. If you provide all that information in your Sunshine Law policy up front, a lot of times it cuts down on people asking questions back and forth. It's very clear to people how your particular body handles its public records requests. A lot of times a a public governmental body will have a sunshine law policy that applies to the entire PGB. For example, a smaller city will have one that applies to the city clerk and their health department and their police department. Other cities, larger cities, may have sunshine law policies that apply to particular public governmental bodies. So for example, the city clerk's office may have one that applies to the city clerk. The health department for that particular city may have one that applies to just their health department. So if a public governmental body is going to have its sunshine law policy that applies to multiple agencies or applies to a single entity within that particular PGB, we recommend that you include who your sunshine law applies to in your policy so that your citizens know who that sunshine law policy applies to. If it applies to all agencies within the city or only specific agencies within that particular public governmental body. We also have a sample request form that members of the public that's on our website that people can download to send a records request to a particular PGB. It's a very generic form, so it can be used to send to any PGB in Missouri. So that can be downloaded as well. We've had some organizations that have actually downloaded that form and modified it and put that form on their website so people can go right to their website to be able to request records from a particular PGB. Okay, let's get into our public meetings portion of our sunshine law presentation. So a public meeting is defined as any meeting of a quorum of a public governmental body that is subject to the sunshine law, at which public business is discussed, decided, or public policy formulated. And those meetings can take place in person, they can take place electronically via email or text, they can take place via conference call, or they can also take place on an online chat or message board such as Zoom or WebEx. There is a misconception with a lot of PGBs and private citizens in Missouri that the sunshine law that a public meeting is not a public meeting if no votes are taken. And that's actually not correct. If a public body meets with a quorum of its officials and public business is even discussed, that is likely considered a public meeting under the sunshine law. A vote doesn't necessarily have to take place for it to be considered a meeting under the sunshine law. So please bear that in mind. So the term shall also include a public vote of all or a majority of members of a public governmental body by electronic communication or any other means conducted in lieu of holding a public meeting with members of a public governmental body gathered in one location in order to conduct public business. So there was like last year, I had gone down to train a particular public governmental body in the southern part of the state, which I will not name. And they had said, well, during our presentation or during our meeting, a lot of times we don't have all the information that we need to be able to, make the decisions that we need to make. So we'll discuss the issue and then we'll adjourn our meeting. And later on, the clerk will go back and she will send us the additional information that we need. We'll review it on an individual basis, and then we will email our vote to the clerk. And I said, that could likely be in a violation of the sunshine law. And the reason for that is because while you're giving members of the public the opportunity to participate in the discussion, you're not giving members the opportunity to participate in the vote. So in that particular situation, you should post notice of another public meeting with the requirements under the sunshine law, which we will discuss in this presentation, for members of the public to come back and have the opportunity to participate in that vote rather than conducting that vote the way that they were handling it. So what is not considered a public meeting? So the term public meeting shall not include an informal gathering of members of a PGB for ministerial or social purposes where there is no intent to avoid the purposes of this chapter. So this comes out of this court case here, Colombo v. Buford. And in this particular court case, a PGB had gotten together for an event. I believe it was for a Christmas party. I'm not 100% sure, but it was a social gathering nonetheless. And during this social gathering, some discussions spontaneously came up about certain things within their community. I think one of the discussions was about employee morale. And as they were discussing employee morale, people were throwing ideas back and forth. Members of the public who were part of that social gathering happened to hear and joined in the conversation. And so they were throwing ideas back and forth. Well, later on, a lawsuit was filed that said, well, this was a public meeting. They were discussing public business. This should have been posted in accordance with the sunshine law. When the court looked at that particular gathering, they noted that all 5 of these bullet points were not present. The event was totally unstructured with no agenda. Nothing was gavelled into order. People didn't take turns talking to an entire group. There was no policy established or no policy positions were taken. There were no trappings of an official meeting. But the court was very careful to note that if any one of these 5 bullet points had not been present, or if that body had gotten together under the guise of a social gathering, but actually intended to hold a public meeting surreptitiously, that the court could have found that that was in fact a public meeting under the Sunshine Law. But it wasn't. It was a social gathering. So we put this slide in our presentation to just remind public governmental bodies that if you are together for a group in a social gathering or in a social setting, and a quorum of your officials happens to be there, avoid discussing any type of public business, because while you don't intend to violate the Sunshine Law, it might be interpreted like that by members of the public. So the best practice is, if you're with your quorum, just avoid talking about public business at all, so you avoid this type of issue entirely. So types of public meetings. So the Sunshine Law refers to 2 different types of meetings, open and closed. Back in my home state of California, we refer to our closed meetings as executive session. A lot of PGBs will have work sessions or special sessions, and it's totally fine if you want to refer to your particular gatherings as an executive session or a special session or a work session, but just make sure to preface each one of those sessions by whether it's an open or a closed meeting. And the reason for that is the only 2 types of meetings that the Sunshine Law discusses, open and closed. So it's easier for you as a body to know what topics that you can discuss depending on whether it's an open or closed meeting. It's easier for members of the public to know whether it's an open or closed meeting. And if our office is looking into a complaint, it's much easier for our office to tell what type of meeting that is, open or closed. It avoids a lot of confusion by just referring to those 2 different types of meetings. So public meeting notice requirements. If a body does hold a public meeting, whether open or closed, they are required to post notice of that meeting, and they have to include on that notice the time of the meeting, the date of the meeting, the place, a tentative agenda, and that tentative agenda needs to be reasonably calculated to advise members of the public of the matters to be considered. If the meeting is being conducted by telephone or electronic means, include a link for members of the public to observe and attend that meeting. So if it's a conference call, a number for them to call into. If it's a Zoom or a WebEx meeting, a link for them to be able to attend those particular meetings. That public notice must be posted at least 24 hours in advance of all public meetings, both open and closed. It has to be posted in a prominent place that's easily accessible to the public. And weekends and holidays do not count towards that 24-hour period. So the plain text reading of the statute, say, for example, that meeting was being held at 5 p.m. on Tuesday, and the preceding Monday was a holiday. That meeting notice would need to be posted no later than 5 p.m. on that preceding Friday. And when we say meeting, a prominent place that's easily accessible to the public, the statute actually says that it has to be posted on the primary place of business. So if it's a city, it should be posted at City Hall. If it's a county commission, it should be posted on there somewhere at the commission headquarters. Emergency or short notice meetings. So if a body has a situation where it holds an emergency or short notice meeting, and anything emergency or short notice is defined by the Sunshine Law as anything that is outside the normal requirements for posting notice of a meeting. So if a body had to hold a meeting on less than 24-hour notice, for example, that would be considered an emergency or short notice meeting. So if they do hold an emergency or short notice meeting, they still have to post a notice of that meeting as soon as practical, and they have to explain the reason for holding that meeting on short notice in the minutes for that meeting. So something along the lines of, for example, the clerk simply forgot to post notice of a meeting. That probably wouldn't be justifiable to hold an emergency or short notice meeting under the Sunshine Law. Some examples that we give that could be interpreted as an emergency or short notice is, say, for example, there was a flood at City Hall and you had public records that were in danger of being damaged, and a body had to make a decision on where to move those public records to. Or if there was a grant proposal where no one was aware of the grant deadline beforehand, they needed to make a decision on where those funds needed to go to. A situation actually came up in January where a particular PGB, it was a smaller village, where their public works department can't take any type of action that's after hours or on weekends. Any type of action by their public works department requires permission of their board of trustees. And back in January, when we had all those storms, when we had trees down, they were blocking roads, they were blocking streets. The public works department couldn't take any action without the approval of their board of trustees. So under a public safety exception, the board actually held an emergency meeting to authorize their public works department to be able to perform those services. When we reviewed the minutes of their that particular meeting, they properly justified that in their meeting minutes, and they also posted as soon as practical physically as they were required to do under the Sunshine Law. So location requirements, a place that is of sufficient size to accommodate the anticipated attendance. So if a body has a hot button issue on its agenda, or they know it's going to draw in a lot of people, best practices is to make arrangements to hold that meeting at a location that could hold a larger number of people. The high school gymnasium or a large conference room at the library. We definitely recommend that even if a body anticipates that there could be a lot of people coming to a particular meeting, make those arrangements beforehand. If you end up needing that larger space and you don't, or if you make arrangements to that larger space and you don't end up needing that space, there's really no harm, no foul. But if there's something on your agenda that could have reasonably been interpreted as something that was hot button or going to draw in a lot of people, and you didn't make those arrangements beforehand, that's when agencies or PGBs can wade into some gray area with the Sunshine Law. So we recommend as a best practice just to err on the side of caution and make those arrangements for that larger area, even if you don't end up needing it. So I mentioned in our public notice requirements that you have to have a tentative agenda. And the statute specifically says a tentative agenda that is reasonably calculated to advise members of the public of the matters to be considered. So when putting together that tentative agenda, the body should put in that agenda everything that they reasonably anticipate is going to be considered at that meeting. If they end up not considering certain things and they end up tabling that to a different meeting, it's been in the tentative agenda, it's not really that big of an issue. But if they discuss something that's not on an agenda, that's when public bodies wade into some area that they shouldn't be wading into. So on our left side of the screen, we have what could be considered a potentially insufficient agenda versus our right side, which is a likely sufficient agenda. So on that left side, we have under unfinished business, we have budget and park permits. Two things that seem pretty innocuous. It's probably not going to draw in a lot of people. But if that unfinished business has to do with a budget proposal for your police department, and the park permits have to do with a New Year's Eve fireworks display where people have young children and animals at home, it's probably going to draw in a lot of people. We had one situation not too long ago where a body was putting under their unfinished business. They were just putting unfinished business with no subtopics like we see under our potentially insufficient agenda. And they were kind of using that unfinished business to discuss anything they had talked about in any previous meeting. There were no subtopics listed. So we advise that body that if you're going to have unfinished business, it's best practice to have those subtopics so that people know what it is that you're going to be discussing. A catch-all unfinished business is likely not sufficient to advise members of the public of the matters to be considered. Recording meetings. So the body shall allow members of the public to record all open public meetings, both audio and video. A body is allowed to establish guidelines regarding the recording process. For example, you wouldn't want somebody walking up and sticking a cell phone in a commissioner or a board member's face. So a body can establish reasonable guidelines regarding the recording process, but they can't prohibit members of the public from recording an open public meeting, either audio or video. One of the questions I got recently, well, what if we record our meetings live on YouTube and it's saved so members of the public can either watch it live or go back and watch those saved meetings later? And as a public service and a transparency matter, we definitely recommend that you do that. However, even in those situations, you still can't prohibit members of the public from recording. There's also no requirement in the Sunshine Law that members of the public let a public body know that they're going to be recording. So members of the public don't have to let the body know that they're going to be recording an open public meeting. The exception to recording meetings is in closed meetings. Closed meetings may not be recorded without the permission of the public body. This is actually one of the components in the Sunshine Law that is actually a criminal offense if a body is recording a closed meeting without permission. So if a body wants to record its closed meetings for whatever reason, we advise that they take a vote on the record to specify who's going to be recording and by what method they're going to be recording. That way it's encapsulated in the minutes, it's on the record, so there's no questions later on that that recording was authorized by that particular PGB. Best practices for all public meeting notices. Post the meeting notices and agendas in an area that is accessible to the public, even after business hours, and consider posting in more than one physical notice. So if a body is posting notice of its meetings, they shouldn't post it in an interior door where members of the public don't have access to that after hours. It should be posted on an exterior door or exterior window. So if that body is locked or closed after hours, members of the public can still view that notice and that tentative agenda. When it's an in-person meeting, only one physical notice is required at the principal place of business. Obviously, as a public transparency, we recommend that a body post more than one physical notice, but if it's that in-person meeting, only one physical notice is required on that principal place of business. If the meeting is being held online, so it's a Zoom meeting or a WebEx meeting, not only does a public body have that physical posting requirement, that one physical posting requirement, they also must post online as well. The statute actually says their website, so they must post if they're having in that online meeting, they must post on their website in addition to posting physically. If a body doesn't have its own website, then a Facebook or other online posting would likely be sufficient for that online posting as well. It's also good practice for a body to be consistent where they post their meeting notices. So if you post your meeting notices publicly on your principal place of business, try to keep those notices in the same location so members of the public know where to go to. And the same holds true for anything electronic. If you consistently post on your Facebook page or on your website, continue to do so just so you're not changing it up for members of the public. That can get confusing to people, and that can precipitate complaints by members of the public. So we just advise, try to be consistent with your posting and your location. On that physical notice and tentative agenda, include the date and time the notice and agenda was posted. So by hand in the bottom left-hand corner, right-hand corner, we advise public bodies to just jot the date and time and the person who posted that. And the reason we do that, it may seem smaller and trivial, but a lot of times a body will print off its meeting notices and the date will be pre-posted on that notice, but they don't actually physically post it maybe till the next day. So if you post that, if you write that handwritten note of when that notice and agenda was posted, we know when it was actually physically posted as opposed to when it was actually printed. Include the name and contact information for your custodian of records. So we advise bodies to include the name of your custodian so members of the public know who to reach out to your body to be able to request records. Be as specific as possible when drafting your tentative agenda items. We talked about what a likely insufficient agenda looks like as opposed to a likely sufficient agenda. We do get a lot of complaints about agendas, so we advise bodies, you'll notice this several times in this presentation, just to be very detailed when drafting your tentative agenda. More detail is obviously better than less detail. So meeting minutes. 610.020.7 outlines the requirements for minutes that are taken by a public governmental body. So in their minutes, they must include the date of that meeting, the time of the meeting, the place or location of that meeting, members present and members absent. So a body shouldn't be listing 5 present, 4 absent. You should actually list who is there by name and who is absent by name. A record of all votes taken, including a vote to close a meeting. So all votes must be on the record. If it's a closed meeting, it must be a roll call vote. So the members of the public must be able to discern who voted what way. Tammy Miller voted yes. John Miller voted no. I was training a couple public governmental bodies together, and one body said, well, our practice is for outlining roll call votes is John Miller voted yes, Tammy Miller voted no. And another body said, well, our practice is just to list everybody's name and who voted yes, and everybody's name and who voted no. Either one of those practices is acceptable as long as members of the public can discern who voted what way. And if it's an open meeting, it doesn't have to be a roll call vote. Best practice is for all votes to be roll call votes. However, in a closed meeting, it is required that they're roll call votes, where it's not required to be roll call votes in open session. If a body is having a closed meeting in their minutes, they must cite the specific subsection of 610.021, which authorizes that meeting to be closed. We've noticed in the past, we've received complaints that a body will just list that section, not specifically, they'll just say this meeting is closed pursuant to subsection 610.021, and they won't list the specific subsection. A body is required to list that subsection. So if your meeting is closed pursuant to legal, it would be subsection 1. If it was closed pursuant to personnel matters, hiring, firing, discipline, or promoting, it's closed under subsection 3 of that section. Don't just list the general section of why that meeting is closed, list the subsection specifically. And if that meeting was held on an emergency or short notice meeting, remember that the Sunshine Law requires that the good cause for holding that meeting on that less than 24 hours notice is required to be in your minutes. And again, our advice is just to be as narrative and as detailed as possible about your meeting topics. Closed meetings, they are generally permissive. They're rarely mandatory. There are some situations where closing a meeting or records is required by law, but generally as a body is authorized, not necessarily required to close meetings, records, and votes. However, if they are authorized to close those meetings, records, and votes, it has to be because of one of those subsections under 610.021. There are 25 of them. The most recent adoption was number 25 that had to do with the personally identifiable information in utility records. So if they're going to close a meeting, a record, or a vote, or any business of a PGB, they do need to cite that specific subsection under 610.021 that authorizes them to do so. Remember that it is not just a best practice, but it is a requirement that all business must remain open unless it is authorized to be closed under the Sunshine Law. Liability most often happens for improper closure, not for over-disclosure. So chances are a body's going to get into more trouble for closing a meeting that they shouldn't, as opposed to opening something that they're not really sure about. We do have some public governmental bodies we've come across that don't hold any closed meetings. They hold open meetings to the public, just because closed meetings have become such a point of contention among some people. So I mentioned if a body closes meetings, records, votes, they must state the specific exception under 610.021 that authorizes them to close those meetings, records, or votes. The Sunshine Law has those 25 different provisions. The ones listed on our screen here are some of the most commonly used provisions. And you'll notice that some of these have an asterisk next to them. Those asterisks denote an evidence-based cutoff. So while a meeting, a record, or vote may be authorized to be closed for a certain period of time, chances are at some point those records, votes, meetings, or ones with the asterisks are going to become an open record at some point. And one of the examples that we give is under the subsection 11 and subsection 12, the sealed bids and the bid process. So say, for example, a body is taking in closed bids to build a new police department or new health department. They can take those sealed bids in closed session. But once those bids have been unsealed, the winning bid has been selected, and all the legal requirements have been fulfilled regarding that particular matter, chances are those records are then going to become an open record. In each specific case, it's going to be different because it's going to depend on where the process stands on whether or not those records become open. So that's a situation where the public body's general counsel or their city attorney or their county attorney is going to look at that particular matter and say, yes, this matter is now open, or no, this matter is now closed, and cite the reasons for that. If a body is going to hire, fire, discipline, or promote an employee, they are permitted to close those meetings under subsection 3. It should be noted that subsection 3 allows a body to close those meetings if they're dealing with one particular individual. If they're doing things broadly, say, for example, they were deciding salary increases for everybody in their PGB, a body couldn't likely hold a closed meeting under subsection 3, because that would need to refer generally to a specific employee that they were taking action against. So if a body was hiring a new employee or firing its city clerk or something along those lines, those are the types of situations where a body could hold a meeting, a closed meeting under subsection 3. Subsection 14, prohibited from disclosure by law. I kind of call this one the catch-all, because while we do have those 25 reasons under subsection 610.021 that authorize a body to close those meetings, records, and votes, there may be other laws outside the Sunshine Law that authorize or require a record to be closed. One of the examples is HIPAA records. There are federal laws that protect the confidentiality of medical records. HIPAA is not specifically mentioned in 610.021. So if a body were going to close medical records pursuant to a public records request, they could likely cite that subsection 14 and then whatever other law it is that authorizes. In that case, it would be HIPAA. There are actually rules and laws that apply to the confidentiality of juvenile records. There are laws that protect the confidentiality of sexual assault victims. So if there is a law that is outside the Sunshine Law that authorize or require certain records, meetings, or votes to be closed, a body could cite those records as their justification for closing those particular items. How to close a meeting. So the statute talks about 2 different methods of closing a public meeting. A public body may vote by an affirmative public vote of a majority of its quorum to close a meeting. So this bullet point is talking about a meeting where a body has had its open meeting and it's getting ready to go from its open meeting into its closed meeting. When they do so, they are required to take a public vote, roll call vote, to go from their open meeting into their closed meeting. Under the second bullet point here, we have a public governmental body may give notice of its intention to have a closed meeting and cite the specific exception from 610.021. So if a body doesn't intend to hold an open meeting prior to having its closed meeting, they still need to post notice of that closed meeting and state the specific subsection that authorizes them to do so. Only close a portion of a facility used for closing that meeting and only discuss business that is necessary that justifies that meeting's closure. So make sure that a body, if is going from it's having its closed meeting, to stick to the topic at hand, don't deviate from the topic, and only close the limited area that is used for having that closed meeting. So best practices for closed meetings. So the 2 subsections that we just saw earlier may appear to operate independently. It may be useful for an agency to apply both processes when closing a meeting. So by announcing a closed meeting with a public vote and including the citation of its specific provision allowing that closure, along with having that vote during the open session to close its meeting, there can be little doubt of the propriety of closing that meeting. So when we were talking about here, where a public body must make an affirmative public vote on the record to go from its open meeting into its closed meeting, they're not required to take that affirmative public vote if they're just having that closed meeting. However, for transparency purposes, we recommend that if you're just having your closed meeting and you've cited your specific section, still take a public vote to go from into your closed meeting. That way everything's on the record. It's a lot easier for members of the public to know that it was authorized to go into that closed meeting because you're citing that specific subsection publicly. And again, just stick to the topic at hand and don't deviate from the limited reason for closing that particular public meeting. Okay, let's get into some public records. So what is a public record? So a public record is any record, whether written or electronically stored, that is written by or of a public governmental body. So the courts have construed public records very broadly. So records can be written records, things on paper. They can be electronic records, things that are held in an email. They can be items held on a thumb or a flash drive. And they can be older forms of records, such as VHS tapes, cassette tapes, even those older little cassette tapes that bodies used to use all of those many years ago. All of those different types of things are generally considered to be public records if they are retained by or of a public governmental body. So what records must be retained? Our office does get a lot of questions about records retention. I have this record. Do I have to keep it? For how long do I have to keep it? So if your question is, do I have to keep this record and for how long do I have to keep it? That's not a sunshine law question. That's a records retention question under Chapter 109. Our office actually doesn't have authority over this particular chapter. This is actually the Secretary of State's office. So if your question is, do I have to keep this record and for how long do I have to keep this record? You'll want to reach out to the Secretary of State's office. If the question is, we're having a meeting, is it open or closed? We have these records, are they open or closed? That's a sunshine law question. So we actually have an email address for the Secretary of State's office, their local records boards that we give to PGBs during our presentation. So public governmental bodies know who to reach out to check on those particular records retention schedules of the Secretary of State's office. The Secretary of State actually has their records retention schedules online, and they're specific. So they have a records retention schedule that's specific to a city clerk. They have one that's specific to a health department. They have one that's specific to a police department. And those are all available on the Secretary of State's office's website. So electronic transmission of records. We always advise public bodies to remember that as a general rule of public records, any record, whether written or electronically stored, that is retained by or of any public governmental body is likely considered a public record. So if I'm a member of a public body, which the Attorney General's office is, and say I'm sending an email to another member of our office, and my email to them from my official email to their official email is, hey, I'm running out to Subway and I'm going to go grab a sandwich. Do you want anything? Because those records are retained by our body, even though they don't necessarily relate to public business, but because we're using our government email addresses, they're generally retained by our body, so they would be subject to disclosure if somebody were to make a request for them. But also under 610.025, an electronic record may be considered a public record if it is sent to a quorum of officials, which includes the sender, and it relates to public business. So if a body, say for example, a board of trustees is sending an email out to everybody on their board to advise them of a upcoming meeting or to give them a copy of a notice or agenda, that is also considered generally to be considered a public record under 610.025. That is, should be retained by the body. So if the message meets the above requirements or the things that we just talked about, best practices is to send it to a member's government issued device or to the custodian of records. There are still a lot of smaller jurisdictions in Missouri that are using Gmails or Hotmails to conduct public business. So if in a situation where that jurisdiction doesn't have an official government issued email address, we advise public bodies to set up an email address for your custodian so that if you're sending those emails over a Gmail or Hotmail and they relates to public business, send it to your custodian. That way your public body now has those records and you don't have to worry about them being on your personal device. We understand that that's not always practical for every particular body to have a government issued email address. So if in cases where a body doesn't have a government issued email address, dedicated an email address that can be used to retain public records so that your body is abiding by what the Sunshine Law requires in regards to retaining records that are required to retain. So records request for public bodies. Submitting an open records request. A requester can submit an open records request a variety of ways. They can do it by letter, they can do it by email, they can do it by phone call, and they can do it in person. The Sunshine Law actually doesn't require a specific submission method. So a person could put a request in any of these ways. We recommend you do it in writing because everything's better with a paper trail, right? That's way there's a record of that request being submitted. I've had situations where somebody has called me up and said, I've made a records request to this particular body. I spoke with this person and I haven't received a response back and it's been 7-8 days. So I'll reach out to that body and I'll talk to that person. That person will tell me, I don't remember ever talking to that person or receiving a records request from that person. At that point, it becomes a he said, she said kind of situation. There's no way to verify that that request actually came in. So we recommend that you do it in writing, either by letter or by email. That way there's actually a written request that it came in to be able to, for us, to be able to look into that. A public governmental body must act on a request as soon as possible, but no later than 3 business days after the custodian receives it. So just because that request was sent doesn't necessarily mean that it was received by the public body. And that comes out of this court case here, Starr versus the Jackson County Prosecuting Attorney's Office. Address the request to the custodian by name or by title. So in this particular case, the Jackson County prosecutor had received a public records request. And the prosecutor's office was actually responding to the request. They were providing the records. But at some point, this public body didn't provide all the records responsive to that request, and the person ended up filing a lawsuit. Well, when the court looked at that particular situation, they found that the prosecutor had named themselves as the custodian of records for that body. And the prosecutor never actually saw that request until the lawsuit was filed. So in this particular court case, the court held that that request was not properly received by the custodian of records. So a person who's submitting a records request to a body should phrase that request as specific as possible and make sure you send it to the custodian of records by name or by title to ensure that it is received by that custodian. You should use language that a reasonably competent custodian of records would understand. A public body needs to be able to know what records are being requested in order to fulfill that request. So that's, if a body happens to receive a public records request, that it's not discernible what records are being requested. There are no date ranges. It's very broad. Give me all your emails. We recommend that a public body, as a best practice, reaches out to the requester and tries to clarify the request. Date ranges, names and titles of employees, topics of documents. Try to narrow down what it is the requester is asking for. And the reason for doing that due diligence and why that is very important is if the requester is requesting records and it's a very broad request and the body doesn't try to narrow it down, they may be providing records that the requester may not want. The requester just may not have been very detailed in their request. The body might also charge for records, and they might be trying to charge the requester for records that the requester doesn't want. Also, if our office is looking into a complaint and we can see that the body reached out to the requester and was trying to narrow down, that goes a long way to try and solving a complaint or getting through a complaint pretty quickly if we can see that was the body was trying to engage with the requester. So in those situations, we do a lot of mediation between the requester and the public body, trying to get that records request fulfilled and make sure that the body understands its requirements under the Sunshine Law for fulfilling records requests. Responding to an open records request. So a public body must act on the request as soon as possible, but no later than 3 business days after the custodian receives it. If the records are not provided within those 3 days, the body must give a detailed explanation for the cause for delay. So if the body can't provide those records immediately, they do need to provide the requester with a reason of why those records are not being provided within those 3 business days. Provide the place and earliest time and date when the records will be available for inspection. So this actually comes out of a court case that was decided against the governor's office last year or the year before, where the governor's office's process was your records will be ready Thursday or a week from Friday. And the court said that that was not an acceptable response to the place and earliest time and date requirement of the Sunshine Law. So a body should give a requester an exact date and time. Your records will be ready Thursday, March 31st at 4 p.m. If the body needs to extend that date out, if there is a reasonable cause for delay, they do need to provide that reasonable cause to the requester, and that date can change, but they do need to provide a hard, fast date and time to the requester. In that 3-day letter, the body should address any fee estimates to make sure the requester knows approximately how much it's going to cost to fulfill the records request. They should also do that initial search to know how many records approximately are going to be responsive to that records request and put that in that 3-day letter so the individual who's requesting those records are aware of that as well. All employees should know the identity of the custodian of records. So say, for example, somebody in a public governmental body receives a request and the person is not the custodian of records, the best practice is for that person to send the request to the requester and also include the actual custodian of records in that email. That way, the custodian actually has the request and know that they need to be responding to it. The requester knows and who they need to reach out to, and they're aware that you're not the requester or the custodian, so that you're not going to be the one fulfilling that records request, so you're not being bombarded by the individual asking for when those records are going to be ready. They know who they need to reach out to. So it's best that everybody's in the same loop so everybody's on the same page. Records can be held in more than one location, especially electronically. So make sure the bodies do that diligent search for all locations. A lot of times a body will have physical records in addition to electronic records. So make sure you're doing your search to be able to find both of those types of sets of records so you can let the requester know. Best practices is to contact the requester in writing, right? Everything's better with a paper trail. So note the day that the initial 3-day response went out on that in writing response. It's similar to what you would do when a body is printing off that public notice, where you handwrite in the corner the date that it was actually went out. You do the same here for that initial 3-day response. Confirm the body's understanding of what is being requested and engage with the requester to clarify any items and address any possible fees. Confirm the way the records will be produced. If a requester requests items in a particular format, a body is required to, and the body is capable of providing the records in that format. They do need to provide the records in the manner in which the requester asks for. Be very specific. A body should be very specific when explaining reasons why the records cannot be provided within those 3 business days. If no records are responsive to a request, the body will still need to let the requester know. We've had situations where a body has not have any records and they just not responded to the requester. A body shouldn't do that. There should always be a response, even if there are no records produced in response to a records request. Redact whenever possible instead of closing an entire record. Been situations where there's just a social security number or some closed information on a document or documents, and the body has withheld the entire document when there's just 1 or 2 words that need to be redacted. There actually is a requirement in the Sunshine Law. I believe I don't know the exact statute, I don't want to misquote it, where if a record holds exempt information as well as non-exempt information, the body is required to separate the exempt from the non-exempt and provide the non-exempt information to the requester. That's actually a requirement for the Sunshine Law. Obvious reasons for closure, such as work product, should be stated on the document. That way a public body's custodian is not trying to look back 6 months or a year later and trying to determine, is this closed? Is this open? If it's stated on the document itself, it's very, very helpful for a custodian. The Sunshine Law does not require a public governmental body to create a new record upon request, but only to provide access to existing records that are held or maintained by the body. We've had situations where a body will not retain a particular record and somebody will make a request for that record. Again, remember that records retention, what they're required to keep and for how long, is a records retention matter. It's not a Sunshine Law matter. One example is when we had a complaint where a individual had made a request for the sign-in sheet for a Christmas party. A body had held a Christmas party and they ran it at their community center, and people during the Christmas party were coming and going, but the body didn't keep a sign-in sheet. And later on, a request was made for a sign-in sheet, and the body said, well, we didn't keep a sign-in sheet. We don't have a record of that, of who was there and who wasn't. So in those types of situations, a body wouldn't be required to go back and create that record. But if it did create a record and it was retained by the body, it is considered a public record and likely disclosable under the Sunshine Law. So the same provisions of 610.021 that talk about closed meetings also apply to closed records. If records responsive to a request are closed, provide a response that generally describes the material being exempted, unless that description will reveal the contents of the exempt information. Again, we recommend that you redact whenever possible and not withhold the entire record. Best practice when closing records to provide information to the requester about what records have been closed in the final response letter. So if a body is withholding records or closing meetings, state again the specific subsection that authorizes them to do so. If a body says, well, we're closing these records and they're pursuant to 610.021 and they don't state that specific subsection, if the requester then goes back to the body and asks for a written reason of why those records were closed, the body now gives itself another 3-day response time under 610.023.4 to provide that information to the requester. So best practices is if a body is closing meetings, records, or votes, is to state the specific subsection in that initial close or that closing letter. That way a body saves itself from a new 3-day requirement to provide that information if they don't require it initially or provide it initially, and the requester comes back and asks for that information later on. Okay, some final thoughts, some top 10 things to know about the Sunshine Law. When in doubt, a meeting or record of a public governmental body should be open to the public. It's always defaulted to be open. Remember that a body needs that legal reason to close those meetings or records. The Sunshine Law applies to all records, regardless in what form those records are kept in, and to all meetings, regardless in the manner in which those meetings are held. The Sunshine Law allows a public body to close meetings and records to the public in some limited circumstances, but it almost never requires a body to close those meetings and records. Except in emergency situations, a body must give 24 hours public notice before holding that meeting. If the meeting will be closed to the public, the notice must state the specific subsection of 610.021 that authorizes that body to close a meeting. Again, a body shouldn't just state, generally, this meeting is closed pursuant to 610.021 and not state that subsection. They should be stating the specific subsection that authorizes that meeting to be closed. Each public body must have that written Sunshine Law policy and a custodian of records named by law. That name and Sunshine Law policy should be available to the public upon request. The Sunshine Law requires a custodian of records to respond to that records request as soon as possible, but no later than 3 business days after the custodian receives it. When responding to a request for its copies of its records, the Sunshine Law limits how much a public body can charge per page and per hour for copying and research fees. Those copying and research fees are contained in 610.026. And there are specific provisions governing access to law enforcement and judicial records. Those judicial records are Missouri Supreme Court Rule 2 that I talked about earlier. And law enforcement records, there's actually a specific provision that talks about law enforcement records, and that is covered in 610.100. So our office is not the only state agency that's responsible for Sunshine Law compliance and enforcement. The state auditor is as well. These are some of the most commonly found violations of the Sunshine Law by public bodies. You'll notice going through these that a lot of these we've incorporated into our presentation in order to try and cut down on the number of potential violations of the Sunshine Law. Lack of Sunshine Law policies and procedures. Remember that 610.028 requires that every PGB have a Sunshine Law policy and a custodian of records named. Meeting notice and agenda issues. A lot of times that meeting notice didn't include that tentative agenda. If a body has that tentative agenda with that notice, they can be one document, the notice and the agenda, or they can be 2 separate documents, but they do need to be posted together. No documentation of when the notice was posted. That's why we recommend in the bottom corner, just note the date and time that the notice and the tentative agenda was actually posted. Meeting minute issues. Meeting time was not included, date, location, members present and absent. Remember that in your meetings, a public body must state who is there and who is not there by name. Votes not being recorded properly. Remember that any vote taken in a closed session must be a roll call vote. Improper citations to 610.021 used for closing meetings. Remember that when you close a meeting, you do need to cite the specific subsection. And improper closed sessions and deviating from closed topics. So if you're going to your closed meeting, stick to the topic. Don't talk about things that are not authorized in that meeting for holding that closed meeting. So in addition to providing training to public governmental bodies, something that we have done, this is new this year, in order to try and help public governmental bodies fulfill their Sunshine Law obligations, members of our office can attend public meetings to observe and provide feedback on Sunshine Law compliance. So observing meetings, sitting in on meetings to make sure that all the requirements are met, Sunshine Law requirements. We can review forms that are created by or utilized by public governmental bodies to help ensure conformity with Sunshine Law practices. This is a situation where a body would send us a form and say, hey, we designed this form to provide to members of the public to make sure that it is okay to be able to request public records. We'll review those records and said, yes, it hits on all the different points of what the Sunshine Law requires. We can observe public governmental bodies responding to or fulfilling Sunshine Law requests to provide feedback and offer guidance. So somebody from our office can sit with the public body as they're fulfilling a public records request. And these services are not meant to provide legal advice to public governmental bodies, but it's only our office's way to try and provide more hands-on and real-world experience to PGBs in their efforts to comply with the Sunshine Law. So we're hoping by reaching out and doing more hands-on, real-world activities with public governmental bodies, that'll try and cut down on the number of complaints that we get and potential violations of the Sunshine Law. And that concludes our presentation. Do we have any questions?
I know there were several in the chat. And of course, I have some questions.
Okay.
I had an experience where the 3 of the board members were trying to figure out a policy they wanted to pass, and they worked on that separately with just the 3 of them, not the other 2, and it was on their own private email. And then they actually sent it off to the newspaper before it was brought up at a board meeting. And I know that the newspaper requested an open records, but the entity had nothing. They had nothing to share because it was done on their personal emails. Now, my sense is, that was a violation of them trying to do business outside of the board meeting. Am I correct?
So we can't answer that question definitively, yes or no. If a body is trying to avoid the Sunshine Law, so they were meeting outside of a quorum to try to avoid their public meeting notice requirements, a court might interpret that was a violation of the Sunshine Law. And remember that our office can't say definitively, yes, it was a violation, or no, it wasn't a violation. The only entity that could actually make that determination would be a court. A court can only hold that a public body did violate the Sunshine Law. There are also some in the Sunshine Law, it talks about that if a body is meeting for ministerial purposes, so they're meeting as in a staff meeting to decide certain things, there might be an exception there. But if the body was intentionally meeting to try and avoid the Sunshine Law, that could be an issue. Without having specific details about what happened, who was there, who wasn't, we couldn't really say definitively if that was or wasn't a violation.
They were doing it via text or email. It really wasn't. They weren't wanting to be a board. They were wanting to be united so they could vote this policy in that they had figured out just by visiting outside of any official meeting.
Yeah, I mean, potentially, but again, without knowing, specifics about that particular situation, couldn't really make a call either way. If you think that this is something that you'd want to file a complaint on, that's something that we could just look at in more detail. So I would encourage you to do that on our website. People can file complaints on our website. It sends an email to our general email box for our office to be able to review.
How is the backlog coming? I thought they'd making progress.
We are making progress. We have 2 different sections of our Sunshine Law practice. There's our external, where we take in complaints about outside public governmental bodies, cities, and villages, and then we have our internal. So they're 2 separate. I'm not really part of the internal. My focus here is external, so we're requesting complaints. In our complaint process, we usually get those complaints into our system and reviewed for complaints against external bodies, usually within 14 days of receiving the complaint. And our process generally is we sit down with our team once a week to review complaints. It's myself, it's Jason, it's our paralegal, Maggie. Sometimes we have other attorneys join depending on our staffing. And we'll look at every complaint that comes in, determine whether or not it falls within the scope of the Sunshine Law. If it does, we will usually reach out to the public body with a copy of the complaint and ask them to respond to that particular complaint. We give them the opportunity to do so. And then when we receive that complaint back, sometimes we'll request documents, sometimes we won't. It just depends on the particular complaint. And generally our focus in the Sunshine Law complaint process, I do a lot of mediating between the public body and members of the public to try and gain access. This year, we've actually had a lot of situations where we've had records provided or response provided after our office reached out. So there's been a lot of that recently, which I'm very, very proud of, having been in this role for only a year. So,
Peg, you're on mute. You have a question?
I do. I work on our committee, Jay, that does Vote 411, and also with the Forums Committee, where we find out who is running for office. And I'm here through the presentation, I'm hearing that if we request information, for an example, through the Secretary of State's office, we usually send an email to the Secretary of State saying, hey, the deadline for filing candidate filings has now passed, and we would like who the candidates are, what office they're running from, and contact information. And the Secretary of State's office usually, if we send the request in the morning, by the afternoon we have that information. They're very responsive. We usually put something in, hey, this is being requested as part of the Sunshine Law, blah, blah, blah. And they always respond quickly. And so I'm also hearing in your presentation that different departments, so the Secretary of State may have what information is required to be on a form. If we wanted other information, or we wanted information that maybe is not on the filing form, I guess we would have to go to the Board of Election at the Secretary of State's office maybe, and ask them to give us additional information, or to have that request that information be put on the filing form. Is that a correct statement?
So the Sunshine Law generally, the Sunshine Law requires a public body to provide access to meetings and records. The Sunshine Law generally does not apply to questions or clarifications, or asking an agency why they took a particular action or why they didn't include something. So you could send that to the Secretary of State or that particular agency, but generally requests for information and not public records or public meetings, that's kind of outside the scope of the Sunshine Law. Does that make sense?
So the candidate filing forms, though, is part of public record.
Mm-hmm.
And so if we say we would like the filing forms or the information on the filing forms, that would be part of the Sunshine Records request, correct?
If the information is on a record and that record is retained by a public governmental body, they would either have to provide that information or state why that information would be closed.
Okay.
But I was kind of referring to if something was not on the form that you felt should be on the form, that's where that would be outside the scope of what the Sunshine Law requires.
Absolutely. Okay. Thank you.
Mm-hmm.
Well, sometimes is you need the email address and it's not required on the form, I believe.
Yes.
For a candidate.
Yes. And that's where he's saying we would have to go somewhere else to see where we might be able to get that information on their form. Yes.
Yeah.
Okay.
Okay. Cheryl has her hand up.
I put in the chat 2 questions. How do we know if a PBG deviated from closed meeting topic, since it was a closed meeting? One. And then the second one is, who monitors government employees for apps that cause messages to disappear? I believe we had that with the former Attorney General. How would we even find out about those kinds of things?
So I will, and the first part of your question referred to closed meetings. A body could, like I said, they're authorized to close certain meetings, not necessarily required to. So if you wanted to gain access to those records, you could make a public records request for those closed meeting minutes, and a body would either turn them over to you or continue to say why it's closed. So as far as the Sunshine Law doesn't have subpoena authority, so our office doesn't have the authority to require a public body to provide information to our office. So most of the work that we do is working with public bodies, working with members of the public. But as far as requiring them to turn over certain records to be able to prove that they are doing things in closed session that they're permitted to do and not things that they're not permitted to do, that's not something that our office has delved into just because of our lack of subpoena authority. As far as the question about the using the apps and things like that, I'm not too familiar with that. Jason, did you have anything you wanted to add to that particular? If Jason's still on our call.
Jason ran away.
No. Yeah. So as far as the apps, I haven't had a lot of experience with that particular question, so I couldn't really answer that.
It came up with working on the former AG's efforts to get his campaign going, and the messages kept disappearing. So, and I'm not sure how they broke that information, but I just wonder, because we are again in election season, how do we know that if candidates and their staff are using those kinds of things to avoid public records?
Yeah, I do not know. That's not something that I've had any experience with, so I couldn't really answer.
Because that went to court, and because the app they were using eliminated it, then there was no public record to have, is what the court said, type of thing. So,
okay,
you know, it was kind of a
Interesting.
catch-22. Terry, you have your hand up.
Yes, Donna and I have been co-chairing this committee, the Kansas City area. So we cover 4 counties, Jackson, Clay, Platte, and Cass. And one of the early groups that we were following were all of our election boards. And we've just experienced that they all have sort of different ways of giving notice. You know, I observe in Platte County, and they kind of have theirs on a regular period, but they don't ever, they have it on their website, but they're so small enough that one of the co-directors is responsible for doing the website as well as everything else. And so I usually just email them, and they'll let me know if there's a change in meetings, or I'll double check a meeting's coming up. But I think, is it Clay County that, Donna, that doesn't have any regularly scheduled meetings? So it's kind of hard to figure out like when they're, you know, we're trying to do it from the standpoint to say, we're watching all the pre-counts, the post-counts, we're watching that everything to assure the public that that our election boards are, you know, doing everything above the board, so there's no suspicion cast upon them. So that's why we want to observe all of them.
They do a good job, but yet there is a little issue. Clay County is one that posts it on their bulletin board in their, I believe, it's what I've been told, posted on their bulletin board. So I think it meets the requirement because it's publicly posted, although it doesn't meet your best practice that says it can be seen even though they were closed. You know, that has to be in a position that it could be observed.
And Platte County has it on the outside of their door, but I don't go by their door every day. So, you know, and thankfully, when we start observing any governmental entity, Donna sends a letter of introduction, introducing the observer to the government body, and just to develop a good rapport. that we're there to, especially with our election boards, to say they're following all of the procedures, they're doing all the checks and balances, and you can have confidence in our elections.
Right.
So it's just a little bit harder. That's one that's been harder for us to keep a handle on because they don't seem to have a regular meeting schedule at all.
Yeah, so in regard to a body, if a body does have a meeting, they are required to post in accordance with what the Sunshine Law requires. But when a board they decide to have a meeting, or how many meetings they decide to have, that's not really within the scope of the Sunshine Law. So
Right.
the Sunshine Law doesn't say a body must have, one meeting a month of their election board or 2 meetings a month for this. It's just if they do have those meetings, they do need to post them in accordance with the Sunshine Law, which is that 24 hours in advance with that tentative agenda.
Is it a reasonable request to contact and ask that, an email be sent if you're going to attend a board? As a member of the public, I would like to attend the next board meeting. Can you let me know when it is?
If you're just asking for a time and date, again, that's requesting information, which is generally outside the scope. But you could ask for a copy of the notice and tentative agenda. You can make a public records request for the next or the upcoming meeting for that particular body. And if they've prepared that meeting notice and agenda, then they would have to provide it to you. We've had some situations where somebody has put in a request for public records and the body has said, well, we haven't decided when we're going to have that meeting, so we don't have a notice or tentative agenda available. And since the Sunshine Law requires that a public body only give access to records that it retains, if it doesn't yet retain those records, then there's nothing to provide pursuant to a records request. But if they do have to provide the notice and tentative agenda to you.
So requesting a copy of the next upcoming meeting notice would be
and tentative agenda.
Okay.
That's what I would say.
Okay.
Well, and that's why relationships make them importance. But we notice that sometimes it really looks like decisions have been made because they just read the motion and they vote, get a first, and the motion's made, they get a second, and there really is no discussion. They just are voting on it. So it feels like they're talking somewhere. Maybe they did all the talking in the committee, or maybe they did a work session. Work sessions don't have to be closed, right? Because I know Raymore actually videos their work sessions.
So again, it would just depend if a quorum of their officials are present and they're conducting public business. Could be. However, again, the Sunshine Law does allow a body to get together and do ministerial things and not have it be considered a meeting. So it's a little bit of gray area without specific information about what they're discussing and how deep they're discussing. Couldn't really make a judgment call on that.
Well, I pat them on the back because they have a scheduled work meeting the second Monday, and their next. Anyway, they're 2 weeks apart, and they're all on YouTube, so you can go and see it.
As a private citizen and as the director of Sunshine Law compliance, if every public governmental body had open meetings for just about everything, I would be out of a job. So it would be a lot easier if they did that. But again, I'll defer.
So the other question I had, it seemed like in on some agendas with city council that they always had listed that they could close for executive session if it was real estate, it was legal or such. They didn't always close for legal sessions.
Yeah.
But it didn't really specify which one of those, if they did close, what it was for. But it was and it appeared to be a way to cover their backside in case they needed to close it,
right?
Type thing. But aren't they supposed to really tell you it was specifically because it's legal?
So if they are going to have
real estate, what specific one?
Yeah, the best practice is they do need to state what subsection it is they're for holding that closed meeting. And we've been advising public bodies that if you're anticipating having a closed meeting, you shouldn't really get into the practice of putting that information on your tentative, your notice and your tentative agenda if you don't actually intend on having those meetings for that reason. If you anticipate having a closed meeting for legal or personnel or whatever, then yes, definitely include it with your notice or tentative agenda. But bodies shouldn't be putting it on as a catch-all. Like, well, we don't have anything that we could discuss, but something might pop up, so we want to have that on there. That's not a best practice, because that's not creating something that's reasonably calculated to advise members of the public of the matters to be considered. So we advise bodies that if you don't have anything that you're reasonably going to discuss, don't include that. If you do have something, it's like, well, this could pop up and you have a specific issue, then yes, include that on that notice, but don't include it on there as a catch-all. That's just not a good practice.
The other thing I've noticed that, public statements, there's been some contention on my library board, and there's a person that, states something every meeting and all, and then in the minutes, it doesn't state what she says. It just says public comments from the name of the person. And also, and I think that this is part of the recommendations, that minutes are really pretty brief. This was voted on and what the vote was, but it doesn't ever talk about discussion, how they reached that. And I almost get the sense that they've been told that's the way to write up the minutes.
Well, yeah, and we advise to, when you're keeping minutes, just to be as detailed as possible. Unfortunately, the Sunshine Law is 50 years old. Last year, 2023, was its 50th anniversary. And it hasn't kept up with the times. And unfortunately, the requirements for what they have to have in their minutes are just that time, date, place, votes taken. It doesn't, that section of the Sunshine Law, 610.020.7, doesn't state how detailed those minutes have to be about the topics of what they discussed. We advise that they be as detailed as possible, but unfortunately the Sunshine Law doesn't require the level of detail to be included in those minutes, which is unfortunate.
Yeah. Joan or Julie, do you have some questions that you would like to ask Jay?
I do have to jump off here pretty quickly. It's 11:30, and I do have another meeting coming up. I can stay on for a couple more questions, but I'll need to jump off here pretty quickly.
No, I don't have it. I mean, you just answered my question, and that's the detail required in the minutes, because I think that's possibly the biggest issue. So I'm making notes that Sunshine Law does not require detailed minutes.
Yep, the only requirements are that time, date,
best practice,
place,
but not a requirement.
Yes, best practice and such.
Okay.
Well, we cannot thank you enough for your time and adding the court cases that have helped. I mean, you added experiences, and that was helpful of the examples, I think, really such. So we appreciate you very much.
Absolutely.
And I'm gonna let you part. I'm going to stop the recording, and I'm going to just talk about our next meeting just a minute after here. So thank you.
And Donna, I will make this presentation. I'll send it to you in PDF format, so you can